So when it comes to the sale of automobiles in Ohio, the Ohio Attorney General has identified specific acts that it has deemed to be deceptive in conjunction with the advertisement of the sale of these motor vehicles, specifically with advertising. And the Attorney General has identified close to 40 specific acts that it has deemed deceptive in conjunction with the advertising. I'm not going to go over all of them, that'd take a while. I just want to go over a few specific acts that I think are noteworthy. So first pertains to interest rates that are set forth in advertisements. It is deceptive to include an interest rate in an advertisement when the interest rate is contingent on getting credit approval, unless there's a disclosure that the interest rate is subject to credit approval or some other similar wording. Another example, it is deceptive to give the false impression about the nature of a vehicle in an advertisement. So you can't use an illustration or a layout or something that would give the consumer a false impression about the vehicle that is actually available pursuant to that advertisement. It is deceptive for a dealer to offer for sale at a specific price or on specific terms a vehicle when it doesn't possess that vehicle or hasn't ordered the vehicle. It is deceptive for a dealer to offer a certain price or certain terms and then not comply with that ad. If a dealer offers a certain price or certain terms in an advertisement, that dealer has to offer that. They can't go back on the advertisement just to get a consumer to the dealer. Basically, the dealer has to comply with that ad. The term MSRP, which is manufacturer's suggested retail price, if a dealer is going to reference that, it could only be the manufacturer's suggested retail price as identified on the window sticker. Can't say MSRP in relation to any other topic or price in that advertisement. It's deceptive for a dealer to obtain a consumer signature before disclosing any defects, damages, or repair costs that exceed 6% of the MSRP. With a few exceptions, and this applies only if the dealer knows about these defects or these damages. And sort of similar to that, if a vehicle has been a demo or a rental vehicle and the dealer knows it, it is deceptive for that dealer to get a signature on any document, any paperwork before disclosing that information to the consumer. And again, another one related to getting a signature on a piece of paper. It is deceptive for the dealer to fail to disclose that a vehicle was previously titled as a salvage vehicle without making that disclosure. So, dealer, if it's selling previously titled salvage and it knows that, the dealer has to notify the consumer about that before getting a signature on any piece of paper. So those are just a few examples, and those apply to dealers and manufacturers. There's a few instances that apply specifically to manufacturers. The real one noteworthy one I found is that when a dealer has ordered a specific vehicle from the manufacturer for a consumer, and the manufacturer has accepted that deal, it is deceptive for the manufacturer to raise the price of the vehicle after it has already accepted that order from the dealer. So those are a few examples of deceptive acts in advertising of motor vehicles. Like I said, there's close to 40 specific acts. It'd be too difficult to go over all of them in one video. The point being that if you feel like you've sort of been duped when buying a vehicle, there may be some recourse for you. You may have a claim under Ohio's consumer protection laws. You may have a claim for additional damages, claim for attorney's fees, so it's something to look into.